involved, but I have my suspicions.
Oh, that's funny. And actually, for many, many years, I did not drink at all. I wasn't raised in a household where there was alcohol. So, and then, oh, I don't know, dozen years ago, 15 years ago, I started drinking whiskey, um, partly for sort of medicinal purposes, partly as a cultural heritage exercise. And, but I've recently given up alcohol again because I really feel like I don't need it. So I'm back to being a teetotaler for the most part. Weddings and stuff maybe accepted. But so yes, there was no drunken limericking last night and this morning, but it was very late. Steve and I had an event we went to last night, and so I just struck my fancy somehow after we got home to do limericks. And we've had a ton of contractors here today. As people probably know, we've had contractors at our house the whole time we've lived here, really, since June of last year. But today is the last day for the one contractor, and the flooring guys are going to finish tomorrow. And so we're actually going to have our house to ourselves, really, for the first time since we moved here. So I'm excited about that. But that gave me plenty of time to do limericks today because I couldn't, right? I couldn't do anything serious with the guys here making all kinds of noise and roaming around the house. So, all right, let's get down to serious business. I thought we would talk about Abrego Garcia first. I sent you guys the order from the judge in Maryland, Judge Zenas. Did you guys have a chance to look at those? Ship, you just dropped off as a co-host, so I'm resending you back that invite. King, did you have a chance to look at those pleadings? Or not pleadings, but the order and the memo from the judge?
The one yesterday?
Yeah, yeah.
Yeah, I did.
Okay, good. So I looked at the docket a little while ago, and the as we talked about last time we talked, I think the government and his lawyers, the immigrants' lawyers, had asked the judge in Tennessee not to release him, even if the district court denied the government's motion to revoke the release order. They asked the court, nevertheless, not to release him for 30 days while this stuff was pending in Maryland. His lawyers wanted to assess his options and see if they wanted to ask for additional relief. King, we talked about this, didn't we? Like other than having him released, I don't know what additional relief you would ask for as a defense lawyer, but okay. So what happened was the Maryland judge ruled first. The Tennessee judge um, did, in fact, rule that he denied the government's motion to revoke the release order. That didn't mean that the release order got issued because the magistrate judge had never issued it, waiting for the district judge to rule in Tennessee. And so the district judge um, affirmed the magistrate's conclusions that the Bail Reform Act did not justify detaining him on the criminal charge, having nothing to do with his immigration status. And the district judge then sent the case back to the magistrate and referred it to her also to rule on this motion to delay the issuance of the release order. And then today, the magistrate granted that motion. It was a joint agreed motion, is what we call them in Virginia, to not issue any release order for him for at least 30 days. So she granted that yesterday. So he's going nowheres yet. He's still in the custody of the marshals in Tennessee. Meanwhile, the judge in Maryland, Judge Zenas, I think first, I didn't look at the timestamps, but I think first she went ahead and granted the lawyers for Abrego Garcia in Maryland, she granted their motion to give him relief, saying that he should be put back to the status quo ante. So basically, what the situation was before he was sent to El Salvador wrongfully, as everyone agrees, by the government, and that her conclusions were that because he's in Tennessee currently in the Marshal Service, once he's released from there, she's ordered ICE not to take him into custody and not to send him to any third country without first giving him 72 hours notice, him and his lawyers. And she's got a footnote in there saying, and that doesn't include weekends or federal holidays. um, so that he has time to raise additional objections to whatever this third country would be. So I thought that was pretty astonishing. I didn't expect her to do that, but reading her memo in order, I see why she did. I don't agree with her about it, but that is sort of what happened. So people completely understand. He is right now locked up in the custody of the Marshals Service in Tennessee and going nowhere for at least another 29 days while more machinations here play out. So far,
Question.
yeah.
Did the Maryland judge indicate she wanted him back in Maryland?
Well, I mean, not exactly, right? She says that ICE can't take him into custody. She says he has to be returned to his status, what she's saying his status was before the bad things happened, meaning that he had to be put back on supervision in Maryland. He was on the program that many immigrants are, where he has a removal order, but he's nevertheless released by the government back into the community with conditions. He has to report every year. He has to keep them current on his address, on and on and on. And so she says that's the status to which he has to be returned. She says that is the status quo ante, that he was basically in the community in Maryland on this supervised release, that if they were going to reopen his case, it would have to be done in the Maryland field office. This is ICE in Baltimore. And that's basically, they have to put him back to that. Now, as I read her order, I don't see how she thinks that's supposed to be practically accomplished. She doesn't literally tell them you must transport him back to Maryland. I didn't read it that way. But
I read it that they can't
right,
detain him,
exactly.
which means if he doesn't want to go back to Maryland, they can't force him.
Right.
So,
Right, exactly. So it's kind of like they have to, if the marshals turn him loose because the federal court in Tennessee turns him loose, then okay, ICE can track him, I guess, and once he gets back to Maryland, then they can arrest him again. Now, I'm not saying that's the right answer. I think that's the wrong answer. But that is reading between the lines, that is what she said. And then in addition to that, the government answered the original complaint today. They had filed a motion a few days ago asking for an extension of time to do that because that their answer technically was due yesterday or today, I can't remember which. And but in the meanwhile, Abrego Garcia's lawyers have filed a motion for leave to file an amended complaint, but Judge Zenas has not granted that motion yet. So that amended complaint is not live yet. It's on the docket, but it's not the operative complaint. And she just ignored their motion, the government's motion to extend the time to file an answer to the original complaint. And so they went on ahead and filed their answer. And there's nothing remarkable in there. It's the typical lawyer's language. They're saying we don't have facts to answer this. These are legal conclusions. We deny things, blah, blah, blah. But I am going to go through it line by line and also the amended complaint. And we can talk about that another night. But that procedurally, that's where that stands. Just so folks know. But what I really wanted to talk about tonight with you guys is what do we make of her order? Ship, you want to weigh in? Or King, I see you. You have a question or you comment?
yeah, my comment is if I'm Abrego Garcia, I head for the border.
Once you get turned loose in Tennessee?
They are prohibited by the Maryland order from detaining me, so they can't stop me from going. I would go to the border and cross it and go to Mexico.
With the idea being that at least then you don't have illegal presence in the U.S. and you could try to come back? I mean,
Get away from the feds, one,
right.
and avoid any kind of punitive detention in some other
Well,
country.
that will make him a fugitive because the release order from the magistrate in Tennessee will have conditions that he has to return there for his trial in Tennessee, which is still, on the schedule. So if he were to do that, he'd end up then being considered a fugitive on his criminal case. So I'm not sure that I would do that if I were him. Ship, what do you want to say?
I actually think that this order really dances on the edge of giving the administration the ability to come right out and say this is a lawless order because there are statutes that expressly say a district judge does not have the authority to do this.
Right. Now she
I mean,
blows
we're
by
not in a
those.
gray area. Yeah, she
Yeah.
doesn't even mention it. We're not even in a gray area. The closest she comes is she says that I have jurisdiction to ensure that my injunctions are obeyed. And one of my injunctions is that you not again violate his constitutional rights.
Yeah.
And therefore, I can micromanage everything you do vis a vis him for the purpose of ensuring that you don't violate my injunction. In other words,
Right.
I can do anything I want because I've been enforcing my injunction. And that to me, that's just breathtaking.
Right. I think she's like seriously on the wrong track here. She says that she brushes off the arguments that she doesn't have jurisdiction by saying, I basically have already ruled that I do. Plus, the underlying issue from her point of view is her prior injunction, as you say, which, just so folks remember, went all the way up to the Supreme Court, and the Supreme Court didn't strike the whole thing down. They said that she could order properly that he be returned to his condition status quo ante, right? Because everyone agreed that the government wrongfully sent him to El Salvador because he had the withholding thing in his order. Okay. So, but I noticed that what the Supremes say in their little thing that they issued was that the status quo ante before he was sent to El Salvador. They didn't say status quo ante before he was detained by ICE.
Yeah, this is a big issue to me. Is that
Yeah,
sort of she has just sort of assumed that his while he benefited from withholding of removal, that granted him some indefinite legal status.
right. She says they didn't have probable cause to arrest him, but he has a removal order in existence. It's got the
And he had been given
withholding, but
and he had been released and he'd
yeah,
been given work authorization and he was told to check in and he was checking in.
right.
And she sort of says, A plus B plus C equals X. That all of those things together means that he has the legal right to walk the street.
Right, but he does and he doesn't, right? Because the supervision with conditions gives him the right to do that, except they can revoke that any time by going to his
Right,
house and
exactly.
arresting him, which is what
Exactly.
they
There's no
did.
process. There's
Right,
no process needed.
right. Now she tries to get around that, and this is another example, as we've talked about several times, that the district judges don't understand the immigration law because they don't do it because they're not immigration judges. So she says, well, he was on this supervision. And so what they would have normally done is opened up his case in the field office, right? Okay, but they didn't have to do that. They could have done exactly what they did, which is go to his house and arrest him, which is why he has to check in and keep his address current with them. That's how it works. She says, well, he didn't, when they went and picked him up, they had an order that says for pending removal proceedings. And then she says, well, you don't have any pending removal proceedings because during the hearing, the government witness said until he came back into ICE custody from the marshals, they weren't going to make a decision as about what to do with him. But that's a different issue from whether or not he has a pending removal proceeding. His pending removal proceeding has been finalized in the removal order, right? So they can pick him up off the street in Maryland or go to his house and get him any day of the week and remove him. She doesn't. They don't need to open a new case on him, and this just shows she doesn't understand how it works.
What's her justification for enjoining ICE from detaining him anywhere else in the country outside of Maryland.
Right. This seems to be it, that she thinks the status quo ante that the Supreme Court ordered is that he has to be put back on supervision in Maryland first, and then from there they can do whatever the law would allow. She does say in her order that, they've got all these things they can do to him, and once they get him back onto what she thinks is the status quo, then they can exercise any of those rights, and she's not going to say anything about it. But she's mistaken what the status quo ante
Yeah,
actually
yeah.
is.
So, but right. So what she is the game she's playing is the way this will work out is she's basically saying, come back to Baltimore. When they start your proceedings, you file a habeas petition that will then end up in my court.
Right. Right,
And
because
then under,
she's not wrong that.
even though she has no habeas jurisdiction,
Right, exactly. Now he can file a
you know,
habeas if they grab him up again. Let's say they do turn him loose in Tennessee, and his wife goes and picks him up and brings him back to Maryland. Okay, they can pick him up again in Maryland for sure, right? And then I guess his lawyers could file a habeas, but now you're back to on what grounds would that habeas lie, and is there any
well,
jurisdiction in the district court?
right. No, but she will say, because she hints at it,
Hmm.
she hints at the right that he has, habeas rights to contest, or to file an asylum petition. He has, that if he's not, or if he's not given the opportunity to file an asylum petition, he's not given the opportunity to contest CAT.
Right.
If he's not given the opportunity to otherwise, object to removal to a third country, if those are denied to him, then he can file a habeas
On
petition.
those grounds. And the CAT,
And
just so people who haven't been listening to us for weeks will know, that's the international treaty. I'm boiling it way down that we've signed on to that says, we're not going to send people to places where they could be tortured, and you have a right to object to that. So she's saying he has another right to do that. This is a disagreement on what the statutory language means. And I think some lawyers could see it one way and some another. But the government has a good argument, Ship, that you've laid out, that he already had that process.
correct. And she also craps all over the idea that that the Secretary of State has already obtained assurances from these countries that people removed will not be persecuted or tortured, because that's the condition upon which the agreement is reached.
Right. She
She
doesn't
she,
like that.
she
She made the point that you thought she would, that it has to be particularized as to him. And that's probably not right
right,
either. Yeah.
and so that's another basis where she will allow a filing, which she will take because it's him, and attempt to interfere in that. She is going to take every step she can take to prevent him from being removed to a third country.
Right, I agree. And I think that she's doing that because she thinks they're not following the law. Now, I think she's wrong about that. But reading what she's got there, I think that's what she thinks. She doesn't know that she's outside of her lane as badly as she is. So, because she's got a lot of stuff in there like, look, you've got all these powers, and if you exercise them properly, then I don't have the ability to do anything about that. So it's like intellectually she knows that, but then her application is so off that she's actually doing what she says she's not trying to do. So it was interesting to me. What did you guys make of it? Because I've appeared in front of this judge. I'm kind of used to her. But to me, the quality of her memo, even though she's getting things wrong, is very different from some of the other judges that we've seen, like this judge in the Planned Parenthood case up in Massachusetts.
That's not a good comparison. That judge she's just off her rocker.
Yeah, well, that's true. But that's what I'm saying. This judge is not off her rocker on this issue. She's wrong.
Oh, sure she is. Sure she is.
Mm-mm.
She has just ignored. She from the very start. My biggest, well, not my biggest.
Mm,
My problem from the very start is she took and internalized the facts of the complaint as accepted them as true and has worked from that. She has ignored the government at every turn
right.
by just waving away the government's arguments and accepting as true everything Abrego Garcia's lawyers have said and argued, because they're arguing to keep him in the country and she wants to keep him in the country.
Right. Well, I don't know if she personally wants that or not. What one thing I do think,
I think she absolutely is on board with the Maryland man
yeah,
thing. That this guy, she is
maybe.
what the subtext of all of this is. The guy's been here since 2019. He's now has a family. He has no criminal history. There's no good reason why this guy should not be allowed to stay.
Right. She may think that, but I'm not sure that's coming through in her writing. It may be coming through in her
I
overall decision making. But
it goes back to her crapping all over the gang identification process
yeah.
used by the Prince George's County
Yeah.
gang
Well,
task force. It's like,
that
what
I'm
do
not.
these guys do?
Yeah, that I'm not surprised about though, because she was a defense lawyer for so long. I would crap all over that too if it were me. But that leads me to another point with her, which is that this judge was a criminal lawyer for almost all of her career, and in my experience, judges who don't had any civil experience as litigants, they really struggle. And she's a new judge. She's only been on the bench a few years. They really struggle when you're dealing with the civil standards, right? She's treating the whole thing as if it's kind of an even playing field as between the two parties. And when one party's asking for injunctive relief in a civil case, it's not. There are presumptions that she has to be applying, and she's kind of blowing by all of those. So, well, you know, the government has not moved to appeal this yet. I suspect they will. They haven't asked for a stay of it either.
I kind of think that as to this one individual person, they're not really in a hurry.
Yeah. Well, they don't need to
He's
be now
sitting
that
in
the
a
magistrate's given him 30 days down in Tennessee.
Yeah.
right, and so he's gonna. I think, and I think they're waiting. I think they have they have won several immigration issues in front of the Supreme Court, and I think there's a couple still waiting, and I think they're just waiting for all of these to kind of play themselves out without having to do something dramatic like just ignoring her order, taking him into custody, putting him on a plane, shipping him away, triggering a whole constellation of contempt
Right,
proceedings.
exactly. Which you don't want to be in front of her on if you're them. Yeah,
It's just not worth it over one person.
right. I agree.
This is not
So
like it's not like the Alien Enemies Act litigation where you're talking about a whole class of people, or the general principle of third country removal, which can impact a whole series of people.
Right.
This is one guy where there was a screw up.
Yeah.
He got shipped off when he shouldn't have been, and they 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 are he is going to end up getting shipped out one way or the other. If he's here another 30 days, he's here another 60 days. I don't think that DOJ really cares that much about an individual case.
Right. Can you try to jump in there a couple times? What do you want to say?
yeah, what happens at the end of 30 days?
Well, then presumably the magistrate's order today says that subject to that being extended, that the issuance of the release order has been delayed 30 days starting yesterday. So it could get extended. Meanwhile, they could work something out. But in any event, once that release order gets issued, it's going to have conditions on him, right? He's not going to be able to, go
Well, but okay, but let me jump in there. That's the rub.
right,
The way he stays in custody is simply not able to meet the release conditions. Don't have a third party custodian. Don't have a place to live.
right,
That
local to
if you
Tennessee,
can't,
or
right,
transfer the supervision to Maryland, which they could do, but that means he'll then be going back to Maryland, and at that point, why wouldn't ICE just take him back into custody again? So
right.
it may just resolve itself no matter what, but it is interesting. Will the government stand down and say, "Fine, we'll let him be released" at all? I think it would be hard for them to do that.
Yeah, that's kind of, and that may be why they're agreeing to this extension because they don't want to have to do that. That's where they would have to stand up to Zenas and say, you can't have a do not arrest order in an immigration. You
Right.
don't have jurisdiction in immigration to begin
Right.
with. Where is your jurisdiction to tell ICE they can't do something?
Right. Right. That's just impossible given his legal status that existed before he set one foot in her courtroom. So, what did you make of the language that she had in there about she's also unhappy that some of these dudes that weren't supposed to go to El Salvador, we sent them somewhere else, and then those countries have turned around and sent them back to El Salvador.
Yeah, there's a what's that called? It's called refoulement, I think.
Yeah.
You know that you can't use a circuitous route where you know they're going to end up where they shouldn't be. Um, but you know, I think the fact that it happens and the fact that it's pre-planned are different things. Now, you know, I'm not exactly sure what the remedy is or what the courts what her involvement would be, since it doesn't involve anybody before her.
She gives that as a reason for, not having any confidence in the government that they're not going to just violate his rights and his, you know, withholding order again.
Yeah,
Oh,
again, I think the issue comes back to, you know, once he's over the border, you know, her interest in his rights, you know, ceases.
right. Really
You know,
diminishes. Yeah.
you know, I mean, if the removal is, you know, in all respects lawful, which, you know, his first one was not, you know, that's the fact that it was unlawful and everybody conceded it was unlawful was the hook for her to maintain some claim on
Right. To
jurisdiction.
do all of this stuff.
But
So, yeah.
right, but if, let's say he's sent to, you know, Bolivia, and then Bolivia ships him to Mexico, and Mexico ships him to El Salvador, she can't then claim jurisdiction over him again, you know, when he's outside the United States
Right.
and was lawfully sent outside the United States.
Right. So, unlike some of these other cases where the government has jumped, the administration has jumped quickly to ask for stays and so on and so forth, they're not doing that in this case. And I think, Chip, you're right. That reflects a concerted judgment on their part that they're not going to try to turn the temperature up on this one, at least not yet.
They may think they can work this out,
Yes, I agree.
find someplace that'll take him, and he consents.
Or you know, that he agrees to, you know, give up the withholding of with removal to El Salvador based on some kind of arrangement that he doesn't end up in CCOT
Right,
in El Salvador.
right, right. So, yeah. Okay. Well, so one thing to look out for is going to be, back to your question, King, like what happens if the magistrate does issue the release order? I mean, I think the conditions will be very informative.
Well, I know one of them. I remember reading earlier, hearing earlier. One of them is, you know, basically the third party custodian of his brother. So he would have to live with his brother, and his brother's in Baltimore. So, you know, that's sort of, I guess that's kind of the rub that sends him back to Baltimore, is to comply with his conditions and not have a warrant issued. He has to go to Baltimore and live with his brother, which then puts him within the reach of ICE in Baltimore.
Right. So it would be interesting to me if the government just decides, well, that's how it's all going to work out anyway. Right? This guy can't really go anywhere. Whether we release him from the courthouse in Tennessee or not, he's not really going to be out of our reach. And so let's just cut all of this nonsense out. Let
Yeah, he's going to be told, you know, he's going to be told what? He's going to be told he has 48 hours to report to pretrial services in Baltimore.
Right.
And if he doesn't, then they can issue a warrant for his arrest.
Right. And that's on the criminal side, so people understand that's separate from the immigration. So, right. I mean, he could take King's route and then, just absent himself from the country, but that'll just compound his problems, I think. Yeah, Steve says if he's going to do that, then he'd be better off cutting a deal to resolve it overall.
Right.
Yeah. So, all right. So that's where it stands. It is not, at least as of yesterday and today, I don't think it's the 5 alarm fire that some folks on Twitter were worried that it was. But we are going to keep an eye on it and see what the latest developments are. And I'll be interested to see if they appeal her order. They don't have to do that anytime soon. So, they may wait it out a bit. We'll see. Okay, then the other thing we wanted to talk about is this all this declassification lollapalooza that we've had here recently. And so, but you guys have anything else you want to say about Abrego Garcia's case before we switch topics?
Nope, I think we're good.
Okay. All right. So I made myself a little list here of these releases that recently have come out, because I feel like there were so many thick and fast, and they're about different things, and some things are about things that are older and some that are more recent, and I'm afraid people have gotten a bit confused unless you're a total nerd about this stuff like we are. And like I see Steve McIntyre in the queue there. I know he's on top of all of this stuff.
Bring
Wait,
him up. Give him a microphone.
yeah. Steve, wait, send me a DM if you want to talk or if you just want to listen. Um, okay, so
Walkfire too. I see
yes,
Walkfire there.
yeah, exactly, yeah.
I mean, hey, some of these guys know more about this than we
They
do.
they do absolutely. So if you guys want to join the conversation,
Undead Foya. There, Undead
yep,
Foya's
Undead
there.
Foya's in here. So you guys, you rather than tweet, hey, they're making mistakes, jump in and help us. But if you don't want to, if you want to listen, that's fine. But what I thought I'd do is for people who know less about this than we do, um, is to give a sort of a brief overview of what has happened. So because it's hard to follow unless you really have been following it closely. So on the timeline, what has happened is first, John Ratcliffe, who's the CIA chief, on June 26th, which is less than a month ago, he released what's called a CIA note, which basically is an internal document that, in this case, was criticizing the work that CIA did in evaluating the 2016 Russia hoax problem. And the note itself was classified secret and no foreign, which means no foreign citizen is supposed to have access to it. And that got released on June 26th, and the note itself was classified, and so they declassified it. Some of it was unclassified, but a lot of it was classified level of secret. And so they declassified that and released it. And that was the first thing that happened. And, that was super interesting. It's, describing, criticizing the way that the CIA participated in the ICA, the Intel Community Assessment that was done at the end of 2016. And, criticizing some of the issues that our corner of Twitter has long criticized, right? Which is that how in the world did you numbnuts decide to rely in any way, shape, or form on the Steele dossier for any of your analysis? So that was the first thing. Then the second release was that the DNI, Tulsi Gabbard, on July 18th, she released a memo with emails attached criticizing, again, the same kind of thing, and showing that there was meetings and discussions with the White House and these senior administration officials about conducting this assessment in light of the election result in November 2016. And this is more closely tying Obama to this effort. So that was the second thing. And then the third thing that happened is that Senator Grassley has long been trying to get declassified and released, and finally was able to do so through the DOJ. So this is Pam Bondi doing this. Um, an attachment that's called an annex to Horowitz's OIG report criticizing the way the Bureau handled the FISA warrant application process for Carter Page. So most of that report was released publicly, but there was an annex that was classified, and it had to do with um, Hillary Clinton's emails, to boil it down, really, really boil it down. And that document, the classifications are so blacked out that you can't see what level was it classified to at the time. Um, so I'm not sure what level that would have been. That happened on July 21st. So that's this week. And then on the 22nd, so 2 days ago, there was another declassification by the DNI, by Tulsi Gabbard. Again, the level of classification is unclear, but I suspect that it was super high and sensitive compartmented information from other information that's publicly available. And this was for, in 2020, the House did an evaluation again of the government, Intel Community's evaluation of the 2016 Russian interference problems. And Nunes, the Republican congressman, was in the minority at that time, and they issued um, a report, a part of a report that the Congress issued. The minority issued a report that was very critical about, again, how the ICA was handled and the involvement of the Steele dossier and so forth. And that has been classified all this time. Now, the Horowitz report came out in 2018, so that's how far back that goes. The Nunes report is 2020. It doesn't relate so much to the emails like the Horowitz thing does for Hillary, but the Nunes thing has to do square on with that the CIA judgments and the ICA judgments, were hopelessly flawed, which kind of circles back to Ratcliffe's original note that he put out on June 26th. So that's what it is. So there's a lot of material there. It's coming from different sources. It's not all about the ICA. The Grassley stuff is about the Horowitz report, which reaches back to how FBI handled Hillary's evaluation of Hillary's server and email problem, I'll call it. The FBI review on that was called mid-year exam. So that's what has been released. So, oh, sorry, Bill is letting me know he got kicked out. Let me send you a new co-host invite there, Bill. Sorry. So that's what got released. King, can you hear me?
Yes.
Okay. Ship is telling me that we've got a problem. I think it might be on his end. Ship, I sent you a new co-host invite. Okay, so that's what got released. And what I wanted to talk about was several things, one of which is how unusual this is, that all of this has come tumbling out now. And interestingly, of course, King, you and I were going to be talking tonight about the JFK files, which were declassified. And JFK got assassinated like a long time ago. Uh, and also, the government past week released a bunch of files related to Martin Luther King's assassination as well. Also, in the 60s, both of those things happened before I was born, I'm pretty sure. So here we have declassifications of things that happened in more recent history. But still, the question in my mind is kind of why is it, in both instances, these old investigations, assassinations, and this more recent misconduct by government officials, why is this taking so long to come out? And that's the first topic. I've got several things I want to discuss, but let's start with that.
Let me start. I think you've got one thing wrong.
Which is
The one that was released yesterday or the day before that's dated, it says it's from 2020. That actually was originally created by the House. It was actually written by Kash Patel by the
right,
House Intelligence Committee in 2017 and sent to the CIA IG. So basically, the House was going to the CIA IG and saying, you need to investigate this wrongdoing connected to the ICA. And so this is in the Trump administration. This is when who was CIA director before Pompeo? Um, or was Pompeo the first CIA director, and then he became secretary? Yeah.
yeah,
So this is when Pompeo was CIA director, and it notes in there that basically it sat in a CIA safe room
right,
and nobody did anything.
right,
And then in 2020, I think it's in September 2020, and this is explained in there. Ratcliffe, um, as DNI, submitted it again to the CIA IG, but this time I think it was for purposes of declassification. It was early on, with 3 months before the election, the effort got underway to start trying to declassify Crossfire hurricane materials,
right.
and some of these items were sent to the agencies with the classification authority to declassify them.
Right. And that's why you're right. That's why on the front of it, it says oversight, investigation, and referral, 18 December 2020. So you're right.
Right.
That's not when Nunes' committee wrote it. They wrote it back in 2017,
Correct.
hot on the heels of the election. But the,
And then they were trying to get it declassified in 2020 so that it could be released ahead of the election,
Right.
and that never
That didn't
happened.
happen. Right.
And we also know something, that was in the same time frame when Trump said he declassified Crossfire Hurricane documents subject to the FBI redacting sources and methods, and it never happened.
Right.
And so they were, and this is, and then this goes to the what I think is still a conspiracy theory because there's no actual evidence of it that I'm aware of, that the Mar-a-Lago raid was actually to try to find the binder of documents that Trump had kept about Crossfire Hurricane that were supposed to have been declassified by his order, but it never happened. So what's interesting to me, and I tweeted about this, the Nunez or the 2017 report from the House Select Intelligence Committee to the CIA raising these issues, which presumably was largely written by Kash Patel, who led the staff on this question, starting with the Nunez memo, is that document now gives us insight not just to the criticisms of the crafting of the January 2020 or January 2017 ICA, but it also gives us information on the source materials. The actual classified documents themselves and what they say or don't say.
Right.
Calling into question the accuracy of the ICA itself, particularly and this is where I think some of the people that kind of yawning away at this, and they're missing. It's kind of hit and miss between the people who think there's nothing new here and the people who think there's a lot new here.
Right.
This proposition that what really is at issue is the unsupported claim that Putin wanted Trump to win.
Right.
Because that's the claim that makes Trump a Putin stooge and justifies continuing to investigate him after the election. The other stuff, just Russian meddling in the election, well, shit, they meddle in every election, and we meddle in
Right.
every one of their elections.
Right. These same documents say, well, how has that changed since 2008? Right.
Right.
So
That's ordinary. That happens all the time. And the second conclusion that Putin was attempting to denigrate Clinton. Well, okay, but and I've heard some very good analysis that denigrating Clinton, because it's a binary. Denigrating Clinton does not necessarily mean supporting Trump. Putin was expecting Clinton to win, and he was just trying to make mischief in advance of her winning the election and becoming president-elect. But that doesn't necessarily reflect a preference for Trump. In fact, I think there's some reporting, and I'm getting way ahead here. We can come back to these. There's reporting there that the Russians really thought Trump was unpredictable and probably would be more difficult to deal with if he happened to win. He was not their preferred candidate because he was more difficult to predict, whereas they had a lot of experience with Hillary Clinton while she was Secretary of State and going back to when Bill Clinton was president. There were no mysteries with respect to her.
right. And then there's sort of neutral factors independent from the personalities, like the issue of, well, the Russians would prefer in general to deal with Republican presidents rather than Democratic presidents because from their perspective, the Republicans don't raise all these nasty issues about human rights and the Democrats do. So, I mean, that's that's like a neutral type factor. So the thing that struck me about when you see what was actually classified is it just leaps off the page to me that this stuff has been classified because it's a criticism of the handling of the ICA, which is not supposed to be a basis for classifying anything.
Correct, and I think, and this is what I tweeted yesterday. I started to mention. Now the general public can see that Devin Nunes, Kash Patel, John Ratcliffe, Donald Trump, and a dozen other people that knew about the classified intel that's behind these documents have known it all along.
Right.
Have known going back to 2017 that the Biden administration or the Obama administration was actually behind, the concoction of that false link. They created it themselves. They put it in intelligence materials that would then carry over to the new administration and in effect poison the well. And they did it on purpose. And they've known it all along. But because the details were classified, they couldn't come right out and say, here's what we know and here's how we know.
One of the frustrations I have with it is that some of the stuff that was classified and has been declassified, or that still remains classified, does legitimately relate to sources and methods, right? A small part of it does, especially some of the stuff about Hillary's emails, because if they disclose that information, it might show from whom they got the documents, some of which they've obtained through various sources and various other methods. Okay, fine.
Yeah,
But
can I jump in a
well,
minute?
yeah, hold on. Let me finish this thought.
Okay.
But even so, the information itself, I think, could have still been released without compromising the sources and methods. They always take that too far. King, what were you going to say?
Uh, Looking at it from a bigger picture, and to answer the question, why is the media generally ignoring
Mm.
this or yawning at it? Uh, is is simple. The and it's in the memo itself. The memo accepts as a given that Russia hacked the
All
DNC
right. So wait,
and
which memo are you talking about now? You're talking about the
the
ICA,
the, the, the Nunez
the news memo,
memo
right? Okay.
accepts as a given, does not contest that Russia hacked the DNC through spear phishing and whatever other techniques they used, and then released
You
uh,
mean through John Podesta's password, which was password?
John Podesta and the other uh, people whose emails were taken and then leaked to WikiLeaks.
Right.
That Russia was behind that. And the yawn is, well, if Russia was behind that and they did it to Hillary, but they didn't do it, they didn't hack Trump's emails. They didn't, it's not a one for one deal. It was all Hillary's side. Therefore, he must have wanted Trump to win. And the, that's kind of not addressed in the Nunes
It's
memo.
not even a logical conclusion. Maybe the Republican campaign just had better information security.
It whether they did or not, um, the fact is that the FBI and the intel community as a whole took it as a given that Russia uh, illegally hacked Democrat emails, and particularly Podesta's emails, and gave them to WikiLeaks, and did it to hurt Hillary. That's the presumption, and the Nunes memo doesn't address that at all. And until that is addressed, you're going to get a yawn by 98, I would say 80% of the country.
Wow.
That's my opinion.
Okay. That angle hadn't occurred to me because I've thought all along that it was nonsense the that it was the Russians who hacked the DNC.
It was. I mean that's the presumption. But we have not gotten any evidence that it was. They just say it. The best evidence we have are the allegations made in the criminal charges against the Russians brought by the Mueller team. But
Mhm.
that's never been to court.
Right.
We haven't seen the work that they rely on. Uh, it's and I know Undead Foya. I'm looking at his avatar right now. Has spent a ton of time trying to get to the bottom of that.
Right.
He doesn't think the Russians were behind that hack at
No, I
all.
don't either.
But
Right.
but again, we haven't got the evidence.
Right.
Let me add something.
Well, wait, Steve McIntyre has jumped in here. So, Steve, you want to jump in here? Unmute yourself.
Sorry, I'm having some I'm having some cell phone connections. Check back with me in a little bit.
Okay. Go ahead.
But and I know he is skeptical of Undead Foya's position, but my point is, uh, right now, as it stands, the FBI and the intelligence community have have drawn the conclusion uh, that it was the Russians that hacked
Well,
it.
it's more like
It
an
was
assumption, right? Because the
yeah. Well,
conclusion
no,
based
no,
on
no.
nothing.
They say it's not an assumption. They
Yeah,
say
I know they say that,
they
but
and the Nunes memo does refer to uh, other information they have gathered along the way about Hillary. Some of those may have come. Some of that may have come from other emails that have not been made public. We don't know where they got them, but they've got them. They've got secret intel that they shouldn't have, and they could make it public or not. But the fact is, if they illegally obtain those emails from the DNC and from Podesta, uh, then they likely are responsible for making them public. And if those are the facts, and there's been no proof so far that they are not
well, that
the
sort of
facts.
drives us into
That
two issues. So let me jump in here. One is that's why I think Grassley's release of the Horowitz Annex is important in this timeline, in this little cluster of declassifications, because part of what's going on in that document is that the Bureau had thumb drives with information about emails that were Clinton's emails, some of which were apparently emails to or from, it's not clear to me which yet, Barack Obama. So that was a hack. Is that the same hack? Is that a different hack? Is that
I think that's
right?
in the context.
Right.
That was a different hack.
Right.
That was the Russian hack of most of the executive offices of the United States. They hacked the federal government,
Right.
and it predated the Podesta hack
Right.
by a good bit.
Right.
So I think that's what that's referring
Right.
to.
I
There,
think so
that's
too.
referring to,
But
yeah.
there's also the issue that the Chinese may very well have hacked her server and have scooped up all of this stuff. So, that they didn't, that the Bureau didn't even review the stuff on those thumb drives is just completely astonishing to me. But meanwhile, Undead Foya has jumped in here. What did you want to say?
Oh, thank you for adding me. I was just going to kind of add a little bit of the nuance that you were just starting to get into. And to the extent that you read any report and it says that Russia hacked the DNC, it requires nuance now because it is pretty clear at this point that Russia, at least through SVR, did hack the DNC because the Dutch intelligence seems to be the entity that was providing us these thumb drives. And they not only provided us Russian intelligence memorandums that have been discussed, like the Clinton Plan Intelligence or the Renteria memo, they appear to have actually provided the emails that could potentially verify those. So, to the extent that any report just broadly says Russia hacked the DNC, that can be read as true and false, depending on the context with which you read it.
Yeah, I'm usually
Because
thinking about it in terms of the CrowdStrike analysis, which I
right,
think is
and that's
bogus.
right,
Yeah.
and that's exactly the problem because that is the hack that the public knows.
Yeah.
If you ask somebody on the street, they have no idea what Cozy Bear is or what hack that is.
Right.
So,
Yeah.
when everybody thinks of the DNC hack, they think of the WikiLeaks release. So, um, you know, we just need that context. And I thought the report that was released the other day that kind of talked about all the extra stuff that Russia had that they could have released and didn't. Um, it sort of adds to the feeling of unease around that Fancy Bear hack because if they had all these emails apparently talking about Hillary being on tranquilizers and all that kind of stuff, you would think if there was a concerted effort ordered by Vladimir Putin, those would be the kind of emails they would have released.
Right, unless they were expecting her to win, and then they're going to use them against her later. But I don't know to what effect that would be. Right. So some of those, I mean, I was a little not impressed, let's say, about the quality of some of that material. Right. Um, so it's again, you have when you're doing this professionally as an analyst for the government, you have to maintain your skepticism and see, okay, does that fit in with other facts that we know? Does this have the ring of truth to it? And that shocked me that then became the justification that Brennan used for keeping the the Steele dossier into the ICA, that he thought it had the ring of truth.
I have a different view.
About it having the ring of
I
truth.
well, yeah, I think we all can agree it does not. No, my view is that the whole purpose of doing it that way with the ICA is to give it the news hook and get it
Yeah.
out. They knew it was bogus, and if I'm right about uh, the strength of, or at least what they thought or believed was the strength of the case, that Russia did hack and publish Podesta's emails uh, and emails from other DNC officials. Uh, that alone would justify a conclusion, I think, uh, absent contrary evidence, that uh, Russia favored Trump. Because those emails did hurt Hillary. They did. They hurt her with the Bernie Sanders crowd, and they hurt her by exposing uh, cozy relations with Wall
Well,
Street.
what's interesting about that is if you read Donna Brazil's book, and she was, in the 2016 election, she was what the DNC had. And they had all this internal polling that showed, to Undead Foya's point, that the public couldn't differentiate between any of these scandals. Right? That they didn't know what any of these differences were, which ones were her being hacked, which ones were her misusing her server, the hack of the campaign versus the hack of her server. Like the public didn't know and didn't care. It was hurting them, but the DNC couldn't break through messaging wise to clarify that in any way.
Yeah, but I'm just talking about the publication of emails that were hacked by somebody, and uh, the there were a handful of emails that did not help her and probably hurt her with some voters. Is my point. So if Russia was behind it, both the hacking and the publication, uh, you can make an argument that they did it to hurt her chances of winning.
Hey, I want to jump in here. I've been cut in and out. I've been trying to get in for 10 minutes, and for some reason my connection keeps dropping. That's why you
Yeah.
keep having to add me back. There was actually some news made a couple of weeks ago on this question that King's raised by one of the guys, and I can't keep the four of them straight, but if you listen to the Ruthless podcast, is these younger 30-something guys who have all been in, staffers in various political efforts over the last 10, 15 years. One of them was a staffer in McConnell's office in 2016 during the campaign, and his account was hacked. Didn't have anything meaningful in it,
Right.
but he knows because McConnell was a majority leader, and he had contacts with a lot of other offices. The security services did provide defensive briefings to a lot of the senior Republican Senate and House members, and their staffs to be on the lookout, either their official accounts or if their campaign accounts were separate for hacking attempts. So I think the hacking wasn't it just happened to be more effective against a couple of high-profile Democrat targets than anything it managed to pull off against the GOP targets. And I think that is more consistent with just the general efforts by the Russians over many election cycles to, introduce as much chaos into the process as they can by getting their hands on whatever material they can and then exploiting it.
Yeah. Brazil talks about that in her book too, where she and some other people, and I think Sussman was her lawyer who went with her, they went over to it's either DOJ or the Bureau and got a briefing also because the Bureau supposedly had information that they were being targeted. And again, even in her book, it's totally unclear whether she somehow linked that to the CrowdStrike problem or whether that was a different effort altogether, sort of along the lines of what you're describing, Ship. So, it was a huge mess. But let's shift to the question of, okay, this is all fine and good about emails and so forth, but the judgment that was different from the September ICA to the December one is that the Russians, Putin, quote unquote, aspired to help Trump based not on email hacks, because they kind of avoided or ignored all of that for that purpose, but because of this dossier problem. And that raised the issue of, well, why didn't the House and the Senate, Hans Monkey was talking about this also with some of his folks the other day on Twitter, why didn't the Senate committee that investigated this, that Mark Warner is now braying about, why didn't they pick up that that was the problem? And I pointed out that we got this tidbit that Brennan had monkeyed with the classification levels. So I think there were actually 3 versions of the ICA, and the most protected version was sensitive compartmented information designated, and therefore it was really only available to a few people. It was available to the president, so it was over at the White House. I think that's what Nunes got to look at that day that he freaked out over the what he went to the White House to see, which again raises my point, my question about this is classifying things for the purpose of obscuring that there are problems, not because you're worried about your sources and methods, because they could not have been worried about their sources and methods vis-a-vis Christopher Steele.
Yeah, okay, yeah, yes, but I mean, I think it's very clear that the sources in some of these instances, set aside Steele and the dossier. I think the concern was the sources in some of these instances are foreign governments.
Right.
That are doing their own
And as I said,
intelligence
that's
gathering.
legitimate. Right.
Right.
And that's a
So
legitimate
so
means for
now there's
classifying. But
to me what I got out of this, what I and I'm going to say right now, I've been doing other things the last 3 days. I have not had an opportunity to read through in any meaningful way the House release, which to me is the most important one so far.
yeah.
But the parts that I was able to just kind of pull out in the time I had to look at it was this question that there was some super secret
Yeah.
document that nobody saw because Brennan wouldn't show it to anybody
Right.
until December 19th, and then only CIA people saw it, and other agencies got read into it, but they never saw the source document.
Right.
And then the House saw the source document. It's like, I think it's described as a fragment of one sentence is the only thing that supports the Putin aspired
Right.
for Trump to win. A fragment of one sentence on the CIA side. Now, then the Steele dossier becomes an FBI contribution. And the CIA guys wanted nothing to do with it. Didn't want to include it. Didn't want to reference it. Didn't want to. And the FBI guys said, "Oh no, it has to be in. That's a condition of our involvement.
Right.
If it's not in, we're not in."
And Brennan personally wanted it in. It's just the people that worked for him didn't.
Brennan is the one that overrode their objections, but the best he could do to prevent their dissent was to simply make it an annex.
Right,
and
but
not
then what
part of the.
happened was there were supposed to be two versions of this, but there ended up being three because they had a
Right,
public release version, they had the version that they sent over to the Congress, which was classified, I think, top secret, and then there was this extra special version that
right.
was what was over at the White House staff, and that's where the Steele dossier was, it, front and center included, which is outrageous.
Leslie, one of the things that I picked up, the versions have to be substantively the same,
Yeah,
right? So
exactly.
if
Exactly.
the high level report has the sealed dossier integrated, so when you're going to pull that out for the other two versions, you're basically watering down Steele's reporting to hide it or to conceal it, and then you leave your conclusion in there that is based on Steele's reporting in the first
Right.
place. So that's the sinister part, is that it's all based on Steele, but they made it so that nobody could figure that out conclusively.
Right. And especially they didn't want the Congress to know that, is what I get. Right. God bless Devin Nunes for figuring it out. The Senate, I think, just missed it because some people were saying, well, how come these senators didn't figure it out? Because the CIA kept them in the dark. That's why they didn't figure it out. They maybe could have gone down the same trail that Nunes did and go over to the White House skiff. But, that's like a lot of extra effort, right? If you're a senator, which again causes me to, I have some process concerns here, right? Was part of what Ratcliffe's note at CIA was about, is that there are tradecraft problems here, but there are also what I think are just overall process problems with how the intel community operates, especially in the current environment. So it shouldn't be legal for the CIA to classify things in such a way that the Gang of Eight, at a minimum, over in Congress, either can't access them or has tremendous difficulty doing so. We have to put a stop to that. Ship, did you want to jump in there? I see you're unmuted. Yeah. Go ahead.
I'll say I agree with you. Congress ought to be able to access all of it.
And these guys at CIA, one of them, I forget what the technical name of the position is, but one of the two that were arguing with Brennan about this. The role that officer has is to kind of be a devil's advocate type position within the agency because they have a groupthink problem, right? They always have had. And it's similar to, if folks are familiar with the State Department dissent cable, so which is a similar device that State Department developed so that if you've got an ambassador or high level staff at an embassy and they want to do a certain thing or they're reporting back certain information and there are other foreign service officers there who think they're really getting it wrong, State Department developed this idea of the dissent cable to communicate that back to Washington, that look, there's a difference of opinion or view here. And it just seems to me that this whole thing, all these releases, all just glaringly jump off the page to me that we don't have enough of this kind of accountability built into the system, which maybe we didn't need before, but we sure as hell do now.
Apart from the process, is this a crime?
Well, this, by which you mean the Russia hoax itself?
Yes.
Yeah.
The way this was created and then leaked and
Yeah.
then made you know made into a message sent to Congress.
Well, let's come at that from this point of view, because I know Ship wanted to talk about that. And one day we're going to, I think, break down what statutes do we think might apply.
Mhm.
Because there is, in light of these events, it has come to light that there are now open criminal investigations at the Bureau into James Comey's behavior, into John Brennan's behavior. Jim Clapper said on the TV, CNN yesterday or the day before, that he's lawyered up, although he continues to open his mouth on television. So I don't know who his lawyer is. And so, the government, the current administration is going to investigate it. Whether they can turn that into a criminal charge, I'm not sure about yet. But it did catch my attention that Tulsi Gabbard, who I think is not a lawyer, Am I right about that, you guys?
Right.
Correct. Yes, she's not a lawyer.
Talking about this as being a treasonous conspiracy, or so let's just get this straight. The treason statute, that folks, that's not going to happen. That 100% is not going to happen in this situation because the conditions for charging treason, one of which is we have to be at war, don't exist. So there will be no treason charge. Now, could there be a seditious conspiracy, like the one that Ship handled in the J6 situation?
That requires the use of force.
Right.
I think the most likely charge that if you could construct it and survive the statute of limitations problem, the most likely charge would be a conspiracy against civil
Right.
rights.
So we're going to talk about that at length one day because I don't see that either. But we don't have all the facts yet. Obviously, you can't prejudge that. So, but what I wanted to talk
Ship,
about.
ship.
Go ahead.
Before you run, Ship. What's your one line opinion on the Jack Smith theory, 371?
Well, the 371 conundrum is you have a line of case authority from the Supreme Court that's very old that does not seem to or allows the type of interference with election interfere. We're talking about the 371 is to conspiracy to defraud the United States. Then you have a more recent concurring opinion, I think, by Justice Scalia that said defraud the United States means to take something of value,
Right.
a monetary value. That the word defraud is used throughout federal statutes, and everywhere it's used, it means a financial crime by misrepresentation.
Or
And
theft
there's
of
no reason,
property sometimes.
right?
Right. Yeah.
There's no reason to think that 371 defraud the United States has a different meaning. Now, there's old cases, I think from the 20s and 30s, that says it has a different
Yeah.
meaning, but Scalia, and I think this is in a concurrence, so all he did is really kind of tee it up for future reference in an appropriate case. That defraud has sort of a financial crime aspect to it, including in 371, so it
That
wouldn't likely be
And this is
applicable
in
here.
line,
the
as we've talked about, with a number of cases that the Supremes have decided the last 15 or 20 years where they have cut back on these sort of very broadly written criminal statutes to narrow them down because prosecutors do what Jack Smith did and go fucking crazy with them.
Yeah, Jack Smith uh, took the bull by the horns, and went down the road that's outlined in the Justice Department's manual. Uh,
Right.
that says that it includes uh, using fraud or deceit as a means to impair the a government or government agency's ability to do its work, do its job,
Right.
to
Yes.
impair
Yeah. Yeah, that is what it
somehow.
says. But then the reasoning of these other cases points out that if you take that on its face also and do it to its broadest extent, it's a never ending extension of facts that you can apply that to, which can't be correct.
Right,
So,
there's no limiting principle
right,
to it.
exactly. So I don't think 371 will hold up, but you could have to go all the way to the Supremes in order to establish that. So, but like I said, we're going to have a detailed discussion of statutes another night. Let me ask you guys this. For the first time, this is why I brought up Tulsi Gabbard's comment about this treasonous conspiracy. For the first time, people are saying out loud from the podium that the former president, Barack Obama, is part and parcel of this problem. And I wanted to get you guys' take. Undead for you, you're still in the speaker box, too, so yours too, if you're can venture an opinion on this. Do what did you guys make of the facts that tend to show that Obama is ordering something unlawful? Because the emails clearly show he asked for the new review, right? And I see a lot of people throwing around, oh, he knew it was unlawful and he asked for them to pin the tail on Trump. And I don't quite see that, at least in the documents yet. What do you guys think?
I, I'll. My answer goes back to what I said before. I don't think it can be unlawful. First, he's got immunity, but immunity aside, I don't see how it can be unlawful for any of them to undertake that effort when they have as an accepted fact that Russia hacked Democrat emails and published them uh, in a manner that was likely to hurt Hillary's election chances. So, given that state of affairs, the fact that he's asking them to find some more evidence to support the proposition, the fact that you're starting out with that baseline, uh, where's even the deceit?
All right. So let's do it this way. That probably backs you into Ship's point that maybe if you're talking about a conspiracy to deprive people of their civil rights, because that's the kind of criminal case where you can be doing your job and still also breaking the law. But let's set aside, for purposes of this discussion, the question of whether or not there was a crime committed. Let's just look at the facts and just talk in more of a layman's vernacular type way. Do you see that the former president Obama is doing something wrong? Let's just use that word. Um, that he, because we all agree, I think, that these idiots wanted to pin this tail on Trump, and were willing to do so in ways that are dishonest. You know, Brennan, Comey, Clapper, those guys. Do we think Obama is in that same category? Because up until now, he has kind of stayed above the fray on that point. What do you guys think?
I might jump in there. I guess I'm kind of a fence sitter because I had a couple sensitive sources tell me something very similar to what Tulsi Gabbard is saying. If you caught the Jesse Waters program, what she said on the program is basically that Obama is the reason that Brennan took some of the actions that he did, and we got the report about Brennan overruling these analysts, excluding exculpatory information or contradictory information, and relying on substandard reports to specifically include the point that Putin preferred Donald Trump. Now, what she is saying and what I've heard is that the reason Brennan did that is because of Barack Obama. But at the same time, you're absolutely right. Based on what has been released in documents, there's absolutely nothing wrong that's been shown on the part of Barack
See,
Obama.
that's what I came away with too, that it's not in these documents, but the documents take us one step farther than we were before, which is that but Obama asked, he did this tasking. He asked them to do the review, right? That wasn't 100% clear before, that he personally said, let's do this. I want you to do this, and I want you to hurry it the hell up. That point I think is clear now. But to your point, you know, did he then wink, wink, and a nod, or off screen, behind closed doors with Brennan, say, "And I want you to skew it"? That's not in these documents. So, but
What she cited last night was actually a whistleblower.
yes,
So
right.
that's to be developed. But at the same time, like if there's actually fire behind all the smoke, you would sort of expect Congress or somebody to start issuing subpoenas to Barack Obama, right? I
Yeah.
mean, if you're going to say he's in a treasonous conspiracy, and then Congress doesn't issue any subpoenas for documents or
Yeah,
testimony, that's
yeah,
you
that's
know
gonna be a problem. There is also the
exactly.
fact that it is apparently the White House that began leaking to the press that same day, the day that they had the meeting, which is I think December 6th, that the Russians were helping Trump. So if that was the narrative that they put out totally in advance of the new ICA coming out, okay, those are interesting facts that can be put into the mix. Ship, what's your take? Ship, are you having problems talking again?
Yeah, you lost Shep.
Oh, he dropped off again.
Yeah. Can I answer that
Yeah, sure, go
question?
ahead.
Um, I view it differently. Partly for the reasons I've already stated. I see it as the the ICA was kind of to set the table. The real bad stuff happened thereafter when they misled Congress, misled the public, and launched this fraudulent investigation against Trump. Uh, that's what ruined his presidency.
Right. And
Uh,
without this, those things would be
without
a lot harder to have accomplished or have done at all.
correct,
Yeah.
correct, but this was not. It's a hard case to
Yeah.
make that this stepped over any lines other than just bad tradecraft, stupidity, incompetence. You
Bias.
bias, what have you. But then they took it and they ran with it in ways that clearly were outside the
Yeah.
lines.
Now,
But
now, okay, can you
wait,
hear me
yeah,
now?
but hold on,
I'm
Ship, hold on. Undead for you, would you mind taking yourself off? Only because I think with so many of us in the box, that's what keeps kicking Ship out. Thank you. You can come back. Wave at me if you want to come back again. Go ahead, Ship.
so uh, as okay. So the prosecutor in me says, I understand the point you're all making, that bad tradecraft, bias, blah blah blah. Keep in mind, overt acts in furtherance of conspiracy do not themselves need to be illegal.
Right.
What you need to focus on is there a criminal conspiracy? Was there at least one federal crime, being committed? Then all of these bias issues become relevant
Yeah.
evidence to perpetrating that
I
crime,
agree. But take
and
your
and
hat
they
off, take
establish
your
the
prosecutor's
mindset.
hat off for a minute and just say, if I wasn't looking to charge a crime, but let's say you were a member of Congress and you wanted to write a report, what do you see linking Obama to the problem?
Well, one thing we have not discussed, and I don't know all the details about this yet, is this issue of the preparation of a president's daily brief set to go on December 8th. That was to say there was no evidence that the Russians had, you know, influenced the outcome of the election. And then that was canceled because somebody, I don't know if it was in the CIA who prepares the president's daily brief or it was from the White House, and said, we're not going to have a president's daily brief that says the Russians didn't have an influence on the outcome of the election. And it was at that point that he, or maybe it was the day before, that he ordered the ICA to be done. And the president's daily brief was then changed and issued on the 9th to eliminate the the Russians didn't influence the outcome of the election uh, comment that was supposed to be in it, and it was
Yeah.
taken out.
I've read. I've read the proposed December 8th presidential briefing to be a little bit more limited. I think it was qualified. They didn't influence the election by hacking
No,
the
absolutely, right.
infrastructure. There was an
But
infrastructure issue,
correct,
which
and that
really never changed.
correct,
I don't think they ever said that happened.
correct.
It's
But
interesting that in
what
those
was
emails you see the president is authorizing the inclusion now of the election infrastructure, which is mostly state based, as a national security infrastructure item to be protected. So people may
okay?
not know this. Let me finish this point. May not know this, but the government has a program whereby it assesses how important things in the commercial sector or in the state governments are to the functioning of the nation's national security. And then they have various plans for how to protect those things. And I think this is the first time that the election infrastructure itself was added to that idea. So they were
Right.
very focused on that point in that meeting, obviously.
Okay. And I take King's point as well made, but the proposition was that the president's daily brief was canceled because they were not, because the Obama administration, whether it's CIA or White House, I don't know, was not going to say publicly, with whatever qualifier, that the Russians did not play a role in the outcome of the election. That he wanted the ICA to be done before
they made any statement
such
on that.
announcement
Yeah.
was made.
Yeah.
And then if the ICA was in fact cooked with a wink and a nod, then now you've created what is in effect a misleading document. Now I want to digress to a different subject just for a moment. Then I'm going to get off because I keep dropping off. I think I'm having connection problems here. That's my problem.
Okay.
Because I have a very weak signal. I just saw John Reeves posted that Judge Ali Khan in D.C. denied the motion to stay her injunction ordering the Trump administration to rehire an FTC commissioner.
Good
Okay,
grief.
now,
Can you make that into English?
what?
Can you turn that sentence into English? This is the problem with lawyers is that
Right. Okay. So it makes sense to me as I say it. So Judge Ali Khan, Trump fired an FTC commissioner, Federal Trade Commission. That we had the same basic lawsuit that we've had, half a dozen times already, where the member of the Federal Trade Commission sues to get their job back on the basis that they're subject only to removal for cause. Judge Ali Khan, a Biden appointee who's actually very smart, and I was impressed by when the few times I appeared before her, she grants a preliminary injunction, and then she grants a permanent injunction ordering the administration to rehire the fired Federal Trade Commissioner, and then the administration files a motion for to stay her pending appeal, so then go to the D.C. Circuit, and she just denied it. Expected,
Yeah.
Now, but the reason John Reeves, as an appellate specialist, had kind of flagged this case because the Humphreys executor case from 1935 also involved the Federal Trade Commission.
Right.
This is the perfect mirror for the Supreme Court to take this directly up, cert before judgment, and solve this problem.
And overrule, hopefully, Humphrey's executor.
Overrule Humphreys, because Humphreys was a Federal Trade Commission case. They can take this Federal Trade Commission case and say Humphreys was wrongfully decided.
Right. So the government, have they appealed that yet? Do you know?
Yeah, they filed. They have appealed. They filed a motion for stay pending appeal, and that's what was denied this afternoon.
By the circuit or by the district judge? By the district judge.
By the district judge. By the district
All right.
judge.
So people know once they're in the Court of Appeals, the Supreme Court has a rule that says they could reach down and take that case if they want to. They don't have a rule that says they can reach down to the district courts and take cases, but they do have a rule that says they can reach down to the courts of appeals and take the cases. I don't think they'll do that. Do you? In this case?
Oh, I think they will.
You don't think they'll let the circuit rule? Okay.
No, no. The circuit's already said that they feel bound by Humphreys.
Right. In other cases, they have. Yeah. Right.
Right. So if they're going to reverse Humphreys, they can take this one up directly, put it on the fall calendar, argue it the first week of October, not do it on the emergency docket.
Right.
They might have had their eye on this one, and thought we don't have to do this on the emergency docket. We can take this one up directly because it's the perfect case to deal with Humphreys, since it's the same commission, and argue it the first week of October on our fall calendar and get the decision out quickly.
Right.
And then all of these cases that involve Humphreys are resolved.
Well, and then that would take a bunch of shit off their shadow docket. So that people understand, this move of reaching down to the Court of Appeals and pulling it up is not part of the shadow docket, as Ship says. It would be a regular petition for cert type situation. So on the merits. And they could either do that on their own or the government could ask them to. Okay, Steve's got a comment here.
I've got a side comment here that has not to do with the merits that you've just discussed, but with the fact that Judge Ali Khan, the district judge, denied a stay. I mean, the Supremes just the other day reversed in this same situation. The Supreme Court said that the harm to the government by keeping somebody in place, if in fact the president is allowed to get rid of them, outweighs the harm to the individual if they're wrongfully put out of their office pending the litigation. So in light of the Supreme Court having just said this within a few days ago, I'm somewhat surprised, to put it mildly, that Judge Ali Khan would refuse to grant a stay pending appeal.
This is it. That very question has come up in other of these same firing cases. And the district judges, and I think she's simply following along with others, the district judges take the position that the Supreme Court granting of a stay is not a
Doesn't
decision
tell them
on the
anything.
merits.
Right. Yeah.
Right. So her view is, if the Supreme Court wants to stay me, that's their prerogative. But I am bound by Humphreys.
Okay.
Well, but Humphreys just has to do with the likelihood of success on the merits. If you're looking at the various factors, that doesn't say anything about the irreparable harm.
Oh, I agree. I understand.
Yeah. So, all right. So we will keep an eye on that. And if you guys are not following John Reeves, then please do so. He's a good guy, and knows a ton about appellate law. So, is there anything else we want to go over with this question about all this declassification? Like, I think I'll just say that there are a number of sort of structural and procedural changes that need to be made, either by the executive or by the Congress, in order to try. You can never completely prevent people from doing bad things if they're fucking bound and determined to do it. But that doesn't mean we can't build things into the system that try to prevent this kind of problem in the first place, and certainly try to prevent the cover up aspect of it, right? That it doesn't get brought to light that people are classifying things because it's a criticism, or because it's a counter view or a minority position, and we're just sweeping that under the rug. There's lots and lots of things we could do, but we don't. Thoughts on this?
You've nailed it. Overclassification is a systemic problem with these agencies, but for oversight, you have to have at least the Gang of Eight having the ability to look behind what they're doing.
Right, the nonsense that the agencies are putting in front of them. Yeah. Yeah. Okay. All right. Any other aspects of this declassified materials we want to talk about? I'm going to read them all word for word, but I didn't have time to do that.
Okay. Are you tabling for now the what is the the referral to the DOJ and possible criminal exposure and statute of
We can
limitations?
talk about the referrals and so forth, but I did want to table sort of any conclusions on our part about, well, what crimes could apply and how likely do we think that's going to be? Because I think if we're going to talk about that, I think we'll talk about it for a while. So,
Yeah, that's a lengthy
yeah, it's a lengthy
discussion.
discussion. I wanted to do that
But
separately, but
to me, that's the meat of it right here, right now, because you've got a completely divergent view, and as it stands now, I don't see, other than lying under oath to Congress or to a court, it's hard for me to conceive of a set of facts that would get a conviction at the present
so
time,
let's talk.
based on what we
Yeah,
know.
based on what we have now, which is part of the limitation that we have. But let's say what the referrals are. So, there's three, but I can only think of two of them at the moment. So maybe you guys can help me out, because I think there is a third one. So John Ratcliffe, the CIA director, referred Brennan to justice for potential perjury charges based on these internal emails showing what Brennan's position was vis-a-vis including the dossier in the ICA versus what he told the Congress. I have tweeted about that. That looks weak to me on technical grounds about being able to prove that it actually is a false statement. But that's what the referral was for. And then the DNI, Tulsi Gabbard, has said, or it's been reported, or both, that she made a referral to the DOJ based on this overall problem for a criminal conspiracy of some kind. Now, obviously, that's not the DNI's job. They're the intel people, not the law enforcement people, and Tulsi's not a lawyer. So I think she's within her rights to refer it over there and tell them, you guys should take a look at this. How far that will go, I'm not sure. I noticed that tonight, uh, not Comey, and not Clapper, but Brennan has announced that he's lawyered up. So presumably that's in response to that referral, right? So was
Yeah, I'm sure of that. I think the exposure primarily involves false statements to Congress or other investigative agencies, and possibly leaking classified information.
yeah, potential. So all right. Well, as I said, we're going to delve into that in depth later, but I think we need a little more clarity, and hopefully, we know the Bureau is looking at it. So hopefully we'll get more information as we go along and we can do a better assessment of, okay, are they going to be able to put a case together along the lines of what Ship is talking about, which would be a conspiracy to deprive people of their civil rights. So if you want to look at that yourself, it's that statute is 18 USC either 241 or 242. 241 does not carry the color of law requirement, 242 does. So that's kind of the most obvious choice, in addition to, King, what you're saying about did they lie to the Congress or did they lie to Durham or Horowitz or I don't know who else, Mueller, or I mean, even Smith. I don't know how much of this would cover slop over into that, but you can't lie to the special counsels either. So we shall see. So that's all I have until tomorrow afternoon when we want to start talking JFK.
I see my friend Walker
Ah,
Fire wants to say
oh, okay.
something.
Let me put you in the speaker box here, Walk of Fire. All right, you're in.
Oh, hey,
Hey,
Leslie. Appreciate you letting me
sure.
on. Um, well, I just wanted to chime in real quick with a little bit of nuance, backing up just a tiny bit on kind of what I'm seeing with the changes to the ICA and kind of what they were trying to push. Um, one thing, and King, I disagree with you a little bit on this, is uh, they do take it for granted that Russia hacked the DNC, but they don't take it for granted that Russia was behind the disclosures, at least not with high confidence. And I think, so they had Russia hacked election systems but didn't do anything. And we know that Russia hacked the DNC, but we don't know if they did anything. And something in that first, one of the emails in the first batch that Tulsi Gabbard released, or not the emails, but it was a readout from the principals committee meeting on December 9th, talks about, what can they do in response to Russia, and can we make this fit within the executive order? I can't remember the number, 13694, something like that, in order to assess sanctions, to push back against Russia, and so they had to push formally the idea that Russia had actually influenced and interfered more than before.
Right, because they
Uh,
couldn't remember. People maybe don't remember. They did all those expulsions of Russian diplomats, and they shut down some diplomatic sites, and they were going to do some sanctions, and they couldn't have justified any of that without this kind of conclusion.
exactly. And I think that was part of what Obama wanted to make sure was in there. And I say Obama meaning all the players. I don't think Obama's going to jail for any
Right, he's
of
not.
that. And then I do think there's a little bit of nuance too, which, hopefully we get some more D-class later. I think there's a little bit more to the Steele dossier. I'll rephrase that to just Steele and Steele's reporting, that I think we might see a little bit more circular reporting there that was hidden in order to justify it being in there. And this is my personal theory that I think one of the sources on the CIA side was also coming through the same reporting stream with Steele, and I think they were trying
I
to
mean,
cover
that
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 up.
that was happening 6 ways for Sundays across all of these things, right? That
Mm.
it's the same idiots pushing the same information through different channels.
Right.
Are, are you talking about the proto dossiers?
No, I again, my theory from what I'm, just it's the picture I'm starting to form. I think Steele took some stuff to the Brits that he didn't send to the FBI, and then the Brits took that stuff over to Brennan, and then Brennan's source, the CIA source for all this stuff, is actually Steele, and
Hey, this lines up with what I got from this other guy. Yeah, same
exactly,
guy.
and that would
Same
make
guy.
sense why Comey and Brennan went back and forth of, well, we can't include Steele reporting here as high confidence and not include it over here because we think it's trash. We have to have it in there somehow too. Plus, we can use it as a hook to leak it. And I think that's the second part of everything is, we've seen Trump in his second term. He's going out and making deals with everybody. And he'd been talking that way through the whole campaign in 2016. I'm going to bring peace, and I want to make deals with Putin. And I think that was unacceptable to Brennan and Obama and a lot of those folks. So, how to keep the incoming administration from being too friendly with Putin is you've got to push this out that yes, Russia interfered and on behalf of Trump, because that really tied Trump's hands in being able to really, negotiate with Putin and come up with whatever he needed to come up with.
Right, govern the way he wanted to vis-a-vis those foreign interests. Yeah.
Right. And so that's the entire push, the Russia, Russia, Russia for years. And I don't know what sort of statute that might fall under conspiracy wise, but they used it to hamstring him throughout his whole first term. And have been trying to up till now to keep him from being able to actually have legit negotiations with Putin because of this, because otherwise the American public would just get too riled up and impeach him or throw him out, or he just wouldn't have the political capital to do it.
Right. Oh yeah, I agree. I think the half of them had this wet dream fantasy that there was going to be a color revolution. People would flood the streets and demand that he resign and shit like that.
Exactly.
Jeez
Exactly.
Louise. King, let me ask you this. Do you think there's enough, forget about for the moment Tulsi Gabbard's whistleblower. Do you think there's enough there for the Congress to subpoena Barack Obama to explain himself, or not quite enough?
Not yet. No. Uh, you know, I'm a constitutionalist. You've got the separation of powers issue, and I don't think they can force him to testify uh, unless something was going on after he left office.
Right. And I haven't seen any facts on to that point yet. I doubt we ever will. But yeah, you have to hold out that, you know, avenue that could that something turn up post his presidency? Sure. I wouldn't say that's a zero chance of that, but I think it's close to zero. So, okay. Well, on that note, I think we should say goodnight, and we'll see the folks that want to talk about JFK tomorrow.
Good night, all.
Good night. Thanks everybody who chimed in. We appreciate it.
Thanks, Leslie. Thanks, King.
Uh-huh. You too. Bye.